Good afternoon, everyone. Thank you for joining me today. My name is Patricia Black, and I work for the City of Mountain View's Rent Stabilization Division as one of the managers over here. Today, we are going to have a webinar on rent stabilization basics, really focusing in on information for new property owners, the people who have just purchased their property, and realtors. We're giving out a bunch of very high-level information, and we will send out an email tomorrow with a link to this recorded workshop, plus our required information sheet. And that will help you with noticing your tenants and giving information out about the rent stabilization and eviction protections in Mountain View. It is September 19th of 2024, and let's get started. So before we move on, I want to mention that I am not able to offer legal advice, but I can offer facts, best practices, an overview of the CSFRA and MHRSO, if anyone's here for mobile homes, and other state laws. I also want to mention that you can raise your hand or use the chat at any point in this workshop to ask a question, and I will keep an eye out for that. If it's something that looks like it's going to be something that I'll cover later on in the workshop, I'll hold off on answering that question until I cover the content. So just know that if your question's not getting answered immediately, that's because it will be covered later on. And I do want to just make a quick note that if you happen to hear dogs barking or other disturbances in the background, please accept my apologies. And let's move forward. Before we get going, does anyone have any questions about how to ask a question? If you are on the phone, if you're joining us via phone, you would press *9. Otherwise, just go ahead and raise your hand or use the chat function. All righty, so here's a little bit about what we're going to cover today, some CSFRA basics. What is the law? What does it do? Who's covered? What is the annual rental housing fee? And we're going to go over mandatory property registration and our portal. So the first thing, the most important thing that you should know is if you own a rental property in Mountain View and it has 3 or more units, or it has 3 or more units, well, what I was going to say, if it has 3 or more units, we usually think of those as connected units. Some properties have a duplex or something where other units are connected that are not covered, but a single family home is on that property. That still qualifies as a 3-unit property, and so that single family home is covered. We'll talk about that a little bit more in coverage. So most units in Mountain View are covered by this law. And this is a voter-approved measure that was voted on in 2016 to stabilize our community by reducing housing turnover in certain rental units. And it does that in 3 ways. The first way is that it provides rent stabilization for fully covered units. We'll talk about the difference between fully covered units and partially covered units in just a moment. The second way that it reduces housing turnover is by providing eviction protections for both fully and partially covered units. And then for those fully covered units, it also ensures a fair rate of return on investment for the property owner. So what does that mean? That means that if you're not able to maintain a fair rate of return, to maintain the operating income on your investment between a certain time period, you can file a petition to request an upward adjustment of rent above the allowed annual rent increase. So we're going to talk about that a little bit more too in the presentation as we move forward. So what homes are covered by the CSFRA? Like I said before, most apartment buildings with 3 or more units are covered by this law. We have both fully covered units, and those are units built before 1995, where both rent stabilization and eviction protections apply. Also, we have partially covered units. Those are the units built between 1995 and 2016. For those units, only eviction protections apply. So what you're going to want to do is, if you're a new property owner, ask yourself, which one am I? You're probably going to be a full owner of a fully covered property, not a partially covered property. And I need to change these check marks. They're a little hard to see. So this is another way that you can think of this. We have a little table here that shows you coverage exemptions or what is applicable to what types of property. So again, if your property is built before February 1st of 1995, rent increase protections, just cause eviction protections, and this little tricky thing called a rent rollback all apply to your property. Why is there this specific date? It's due to state law, a state law called Costa-Hawkins. And that state law puts some restrictions on what local jurisdictions like Mountain View can do to reduce housing turnover in their city. And then the second type of coverage is partial coverage, and those are where just cause eviction protections apply, and those buildings are units built between February 1st, 1995 and December 23rd, 2016, which is the effective date of our Mountain View CSFRA rent stabilization law. And then finally, we have buildings that have no coverage whatsoever, and those are buildings built after December 23rd, 2016. Now, there is also a state law called AB 1482, and there are rental protections that apply to buildings that are not covered by the CSFRA. So you're going to want to learn about state law AB 1482 if you're not fully covered by our law. If you are fully covered by our law, you don't have to worry about it. It doesn't apply to you because our local law is more protective than the state law. So there are also other types of fully exempt units. Now, single family homes are on this list, but keep in mind that if you have 3 or more units on your property, those single family homes will be covered. So we even have this one kind of crazy divided property in Mountain View where there's an apartment building with 8 units. We have 6 single family homes and a duplex. Everything on that property is covered except for that duplex. So just keep in mind, if you have a question about what's covered on your property, just give us a call. Okay, I'm going to give you our contact information at the end. Just reach out and say, hey, is my property fully or partially covered? And we'll let you know. Condominiums are not covered. ADUs and companion units are for the most part not covered, but you're going to want to check with us. Duplexes are not covered. Units in hotels, motels, etc., that are rented out for less than 30 days are not covered. Units in hospitals, medical care facilities, and dormitories aren't covered, and government or subsidized rental units are not covered. This gets a little tricky because the definitions of what all that means gets a little cloudy. So again, if you think that you might have a property that's covered by our law, or you don't know, just reach out to us and we'll go into our database and let you know what the coverage is. So the law that was passed in December of 2016 created this program with all of these protections for tenants and all of these laws and regulations, right? That law says that this program is funded by a fee paid for by property owners, and it's a per unit fee. In 2024, the fee is $108 per unit. We're going to have a new fee that is a little bit higher than that for the new billing cycle starting in 2025. And I'll have that updated for you on these slides when we send out the presentation tomorrow. The payment of this fee is due in January, by January 31st of every year. And if you don't pay it on time, there are fines associated with non-payment or late payment. So we send out aggressive communications about this. It will be on our website. You will receive multiple notifications. We send out a letter in the fall. You will see it in our newsletter that we send to you in the fall. You'll receive a postcard, multiple postcards about it. We will send out your invoice at the beginning of January of 2025. You'll receive additional mailings from us. And then If you haven't paid your fee by the time it's due, that next month you'll receive a notice from us that says, hey, you haven't paid your fee, you need to pay this. If you still don't pay it, you'll receive a notice of noncompliance. If you still don't pay it, your tenants will receive a notice of noncompliance. Why does noncompliance matter? Well, you're not able to raise your rent on your property if you're out of compliance with the law. So you have to pay your fee on time by January 31st to be in compliance with the law. If you haven't paid your fee and you give rent increases, those rent increases are unlawful. They're not allowed, and your tenants can petition the city to have a refund in rent for any rent that they've overpaid. If you remain in violation of the law, if you haven't registered your property, you haven't paid your fees for multiple years, and you give rent increases, that amount can really balloon over time, and your tenants are legally able to recover those overpayments in rent through our petition system. That is also part of the CSFRA law itself, which we'll talk about a little bit more in the future of this presentation. The other kind of piece that goes along with paying your fee, it's due at the same time. So January 31st is registering your property in our portal. Luckily, this year, most properties have registered with us. You do this by going to mvrent.mountainview.gov, and you'll see you'll register your property by logging in, creating an account, and then going to your specific property, claiming your property, and putting in information about that property, including your contact information and specific information about each unit on your property. You also, through this portal, submit required noticing, including termination notices. They have to be filed through this portal. And banked rent increase notices. We'll talk about banked rent increase notices a little bit in the future of this workshop. And then tenant buyout agreement forms. So all of those have to be filed with our system. And again, you have to register each unit in the system every year. So once you get the information about the unit in the system, so how many rooms it has, how many bathrooms, all of that information, it's going to be there until you change it, until there's a vacancy or if the unit goes away. If the information doesn't change, you just come in to the portal at the beginning of 2025 and you say, this all looks great. You click submit and that's it, you're done. If you have had new tenancies or a change in rent, really, I suggest that you update that when they happen so you don't forget. But if you haven't done that, you're going to come in and update the information and then click submit. Now, make sure you click submit, because if you don't, then the registration is not complete. It's a big red button, so look for the red button. We've tried to make it as visible as possible. So if you are struggling in any way to register your property, you can always just reach out to us. We hold workshops during that time of year every other week. Sometimes we hold them twice a week. Sometimes we hold them every week. You will know, we will send out information about the workshops and when they happen. They are typically virtual because that's so much easier for property owners to attend. If you need in-person support, though, we are also here in person. Okay, before we move on to local, to landlord rights and the federal, state, and local laws, I just want to pause for a moment and see if there's any questions about what I just covered. And again, you can ask questions by just using the raise hand feature or typing in the chat. Okay. Doesn't look like we have any questions right now, so I'm going to keep going. I'm going to cover this part really quickly. These are important laws for you to know as a property owner. You should be reading these. This will really help you understand what you need to do under the law. The first thing we'll go over is federal law. So there are kind of two major federal ones that you should be really thinking about. That's the Fair Housing Act, also known as the Civil Rights Act, Title VIII, and the Fair Credit Reporting Act. We have 4 state laws that you should be well aware of, including California Civil Code 1925 to 1954.05, 1954.50 to 1954.605, and 1961 to 1995.34. Also, the California Investigative Consumer Reporting Agencies Act is important to know, the Fair Employment and Housing Act, which is also known as FEHA, and the California Civil Rights Act. So those are your big ones for the state law. And then locally, we have the Community Stabilization and Fair Rent Act. If you're a mobile home owner, the Mobile Home Rent Stabilization Ordinance, the Tenant Relocation Assistance Ordinance, this is a really important one, and City Code Chapter 25. Also, California state laws, AB 1482 is important to know. That's the one that's all about rent stabilization and just cause eviction protections for properties that are not covered by the CSFRA or MHRSO. And SB 330, which is another one that, similar to our tenant relocation assistance ordinance, has to do with the demolition and removal of units from the market and what you as a property owner have to do during that process, including providing monetary compensation for people who are affected by the demolition of the property when you redevelop. So some of your rights as a property owner: during pre-tenancy, of the right for tenant screening, rental agreement, house rules and disclosures, and a security deposit. And also you need to be aware of reasonable accommodations requests from your tenants. During tenancy, you have the right to demand a rent payment and issue notices of rent increases as long as they follow the law and as long as you're in compliance of the law. Maintaining the property as a habitable and quiet enjoyment opportunity for your tenants, and respond to reasonable accommodation requests and modifications of those requests. During the termination of tenancy, you have the right to terminate tenancies for 9 reasons in the city of Mountain View. We'll go over that in a little bit. Then there's also noticing requirements within that. And again, you need to be aware of all of those reasonable accommodations. And then finally, post-tenancy, you as the property owner have the right to, a portion or all of the security deposit if the tenant has damaged the unit beyond reasonable use. You have the opportunity to provide tenant relocation assistance, as we discussed. And again, those reasonable accommodations are always something to be considering. Okay, before we move on, I told you that was going to be a really high level. Is there any questions? Taylor, I see that you have your hand raised. I'm going to allow you to talk, and I'll see if I can answer your question. Now, keep in mind, I can't provide legal advice, but I should be able to answer your question. Oh, Taylor, can you raise your hand again? I think I unmuted the wrong person. There we go. Go ahead and unmute yourself.
Hello, can you hear me?
Hi, Taylor. Yes, I can hear you.
Yes, I just have a question. Are we allowed to require renter's insurance?
You can put that as a term in your lease.
Okay. And in case, the resident doesn't fulfill that requirement, are we allowed to bill them for the insurance for the placement?
You would
Or
have to state that very clearly in your lease.
I had to be okay.
Yeah.
Got it. Okay, I will do. Thank you.
Not a problem. Thank you. All right. Before we move on, are there any other questions? Taylor, I'm going to go ahead and remove your permissions.
Thank you.
And if you want to go ahead and lower your hand, that would be great too. Thank you. Okay, so we're going to go over pre-tenancy, screening, rental agreements, and reasonable accommodations. So we touched on this very briefly in the last section. So for screening, you can screen for creditworthiness, rental history, past evictions, income. And the screening has to be non-discriminatory. So things that you can screen for are names and ages of occupants, phone numbers, prior address. You can request a copy of a pay stub, a bank account number. but you cannot request immigration status, familial status, ethnicity, medical information, or copies of bank statements. So keep in mind there's a difference there. You can request a bank account number, but you cannot request a copy of bank statements. So you really want to make sure that you're not wading into potential lawsuits or concerns around discrimination. There are fair housing laws that impact you as a property owner, and if a potential tenant feels that they are being discriminated against, they can request assistance for that potential discrimination from legal counsel. So what constitutes fair housing discrimination? Discriminating based on race or the color of someone's skin, discrimination based on religion, national origin, primary language. So what language, discrimination based on language or not providing language access materials, immigration status. You cannot ask for someone's immigration status in the state of California. You cannot request information on familial and marital status or gender, identity, sex or sexual orientation. You cannot discriminate based on disability or age, source of income, or just arbitrary reasons. If tenants feel that that's happened again, they can seek legal assistance, and there are federal laws around this. Rental agreements. We'll touch a little bit on what Taylor had a question about. So what can go into a lease? If it's month to month, the fixed lease term, the name of the owner and agent, who, where, when to pay, rental amounts, utilities. Utilities now have to be included in new leases, the amount of the security deposit, whether or not subletting is allowed. Potential fees need to be disclosed. Disclosures about the property, like lead paint or asbestos exposure. There are ones that are required in the state of California. And house rules. So for instance, requiring rental insurance can go under something like house rules. Now, just to keep this in mind, this is actually a carve out in the CSFRA, the actual law itself. I believe it's section 1713. Don't quote me on that. Tenants cannot waive their rights through signing a lease. So if you were to put into your lease something that contraindicates the CSFRA, that says something against that is fundamentally against that law, the tenant, even by signing the lease, can't waive their rights. They can't say, oh no, I give up my rights under the CSFRA. That's not allowed. Even if they do that, their rights are still there. They're still available for them to use and access, and you still have to follow the law. Okay, so before we move on to what happens during tenancy, what you as the landlord have rights to, does anyone have any questions about what we just covered? Again, you're going to use the raise hand function. Okay, seeing none, we'll keep rolling along. So we're going to cover those big issues that we discussed: rent payment and increases, habitability, the right to enter, and reasonable accommodations. So rent, this is important. This is for our fully covered units only. This does not apply to partially covered units. So what is included in rent? The initial rent of the physical space, parking fees, pet fees, utilities that are not sub-metered are part of rent. RUBS and conservice are not allowed for new tenancies. That started from March 1st of 2024 moving forward. That has always been part of the law, and we are now in a transition process for any property, we'll talk about this in a little bit, where RUBS is being utilized at the moment to transition into including those utility charges charged through RUBS into the total rent amount. And housing services and storage are also considered part of base rent. So if you have a pool and your rent is $1,000, the use of that pool is considered a housing service and it is part of rent. What increases are allowed? There are 3 ways that you can increase rent. One is the annual general adjustment of rent, otherwise known as the AGA. This is your annually allowed rent increase. We also have the ability to increase rent beyond the AGA through a variety of petitions where you as the property owner can petition the city requesting a rent increase above the AGA. And then there's also the banked rent increases. So banked increases are when you don't use your annually allowed adjustment of rent. It doesn't go away, it just hangs out waiting for you to use it. And then once you decide to use it, there are specific requirements for that use of that AGA. Deposits are not included in rent, and they cannot be increased once they're kind of in the world from your lease. Once someone signs the lease, that's the deposit. So it's not considered rent. Like I just said, this includes pet deposits, and it cannot be increased during tenancy. Now, if something drastically changes and all of a sudden there's a pet that includes that the tenant wants to have, you'll want to contact us for helping you figure this out. But there are ways to add a deposit for a change in tenancy like that, and change in the terms of tenancy. But you'd want to contact us so we can help you make sure that it's done lawfully within the confines of the CSFRA. Okay, so like I was mentioning, there are specific rules, regulations clarifying what it means for utilities to include rent. For rent to include utilities, excuse me. For new tenancies as of March 1st, 2024, RUBS, which is the ratio utility billing system, is not allowed. The total rent must include the utilities that were previously charged through RUBS, and the rental agreement must state the total rent amount and specify the type of utilities and housing service fees that are included in that rent, okay? But utilities that are paid directly to the by the tenant to the utility service provider like PG&E or are sub-metered utilities, they are exempt from this. So tenants who have sub-metered PG&E will still pay their PG&E bill. It's really just those instances where there was something like RUBS, or the tenants were paying directly to the landlord and they were doing something with similar to RUBS, that that is affected by this. This is a kind of complicated thing for you to understand, so I'm going to finish this, and if you have additional questions after that, we can connect to walk you through what needs to happen regarding this clarification of the regulations. For tenancies that existed before March 1st, RUBS can continue until a utility adjustment petition is filed with the city and approved. There's a petition process that every single property owner and every single unit has to go through, whether or not the adjustment applies to that unit, because tenants have to have the ability to respond and dispute the petition. Utility charges for vacant or newly rented units may not be allocated to the existing rental units through RUBS or similar systems. And if you're confused by that clarifying sentence, just contact your billing provider and let them know that you need to change the way that the allocation is being divided, and tell them that exact phrase and they will help you with that. They know exactly what that means. Okay, so in order to get back into compliance with the law, because you as the property owner were charging utilities through RUBS instead of including them in rent, which is technically not allowed under the CSFRA, there is a utility adjustment petition. And this is a one-time process within a limited time frame. As the property owner, you have to file the petition within a certain time frame to incorporate utilities currently charged separately that are not sub-metered into the fixed total rent amount. Okay, so you can see kind of the process here. We have our physical current space rent plus our separate utilities billed through RUBS. And then we add those two together through the utility adjustment petition process, and we end up with a new total rent. So landlords have to complete and submit a petition to qualify for and apply the adjustment, and that you have to receive a petition decision from our office in order to be able to utilize the adjustment. So before I move on, Taylor, I want to go ahead and see if I can answer your question. I'm gonna allow you to talk, Taylor, and Eduardo, I see you there as well. So Taylor will go first, and then Eduardo will have you ask your question. Go ahead, Taylor.
Hi, Patricia. Just have a quick question for you on this sub-metering. We have a portion of our property that is sub-metered for both electric and gas. Those are obviously actual readings of tenant usage for both electrical and gas. Those sub-meters are then billed through Conservice. Their actual bill is produced and billed through Conservice. We've had some confusion regarding if that is exempt or not. Obviously, we feel that it should be exempt because it measures actual usage. But just wanted to confirm and get your thoughts.
Are they billed for their actual usage? So is what they're receiving from Conservice their actual usage bill?
Correct.
That is okay.
Perfect.
Yeah.
Thank you.
Not a problem. Thank you for the question. And I'm going to go ahead and remove your permission to talk. And Eduardo, you are now able to talk.
I can you hear me?
I can mostly.
Okay. Sorry, my mic is failing, but if I can try.
Yeah, I can't quite make out what you're saying, other than I hear that maybe your microphone is not working correctly. Do you want to go ahead and type in the chat?
Yeah, I believe it is disabled.
Oh, sounds a little bit better. Do you want to try asking your question? Oh, the chat is disabled? That's strange. Let's see. How about now? Can you go ahead and type in the chat now?
Sorry about that. Is this better?
I can hear you now. Yes, I can hear you.
Okay, thank you. So yeah, I'm just a little bit curious on um how we would be able to add like would we need to do some sort of investigation of how much a tenant was paying maybe for one of the units to be able to determine what we would need to charge them within the utilities?
So there is this whole petition. There's a whole petition process that you have to go through with the city to determine that. So yeah, there's a petition process with forms and calculations, and you have to file that with the city to be able to determine what the adjustment is.
Okay, I
And
see.
you are required, I should say this, you are required to file a petition as a property owner of a fully covered unit.
Okay, yeah, that was my question because I mean, you know how RUBs work; they are very variable. So I think that it makes sense that the city would work on getting that sorted out through the petition. And I'm also curious. I don't think we actually have any properties with RUBs in Mountain View. But if we were to in the future, uh, how much time would we have to file for this form, or is it only for this year? How would it work?
So you can't have rubs in Mountain View. So there's no,
Okay.
in the future, it's just not allowed anymore. So you're gonna wanna go to mountainview.gov/rubs to learn more. Even if your buildings don't have rubs right now, you still have to file a petition with us. So you're gonna wanna go to this website and read about it and get the information about it, and then figure out how many units on your property you have, to determine your submittal deadlines, because there are deadlines associated with this, and then file your petition with the city.
Okay, even if we have properties with no rubs,
Correct.
multifamily with no rubs. Okay,
Correct. Yeah.
that is perfect. Thank you so
Because
much.
the tenant has to be able to respond to the petition. So, there could be a situation where a property owner is saying, oh, hey, we don't have RUPS, but in reality they do. The tenants need to be able to respond to the petition to say, actually, we're paying through RUBS right now. So all properties have to file a petition with the city. If you don't have RUBS on your properties, there is a condensed workbook. It's a short workbook. So you just put in the basic information in that workbook for each property, and the petition, complete the petition form and go through the steps, but you don't have to do the big workbook. You only have to do this smaller one that we created for you. So
Okay.
you can go ahead and contact us for more information or join our office hours. We have them every Thursday. And you can sign up by going to mountainview.gov/RSP office hours. I'm going to go ahead and put that in the chat for everybody as well. We have them every Thursday from 1 to 3, and you can get more assistance for your unique situation.
Got it. Thank you so much for your help.
Of course. Thank you for your question. Okay, so we're going to keep moving on. So what is base rent? Base rent is one of two things. It's either the amount, if the tenancy started on or before October 19th of 2015, the base rent is the rent in effect on October 19th of 2015. If the tenancy started after October 19th of 2015, the base rent is the initial rent at the start of tenancy. There's something called a rent rollback. If you did not do the rent rollback when the law went into effect, and you gave rent increases, all of those rent increases that you gave since 2017 are unlawful. So it's kind of a big deal. You can imagine that amount of overpaid rent is quite a lot. And we are still seeing people that have tenancies that are in violation of this, where the tenant files a petition with the city and is owed thousands and thousands of dollars. So you really want to be on top of base rent, make sure that tenants are paying the correct amount of rent, make sure that if you as a property owner or the previous property owner were in violation of the law and gave rent increases, that those rent increases are rolled back. The rent is reset to when the violation of the law occurred and the overpayment of rent is paid back. If you need help with that, or if you have questions about that, you can contact me and I can walk you through what you need to do to fix the violation. Typically what it looks like is the landlord notifies the tenants that there was a clerical error, that they're going to receive a refund, either as a rent credit or a one lump sum check. And then after that, you have the ability to implement rent increases that weren't used. Unless you're a new owner, then those rent increases, the banked rent increases, are not applicable to new owners. So it can be a little bit nuanced. If you think you're in this situation, just give us a holler at mvrent@mountainview.gov, and we can get you straightened out. So there is a law, AB 2219, where you as the property owner must accept third-party payments of rent, and if the third party provides signed acknowledgement that they are not currently a tenant of the premise for which the rent payment is being made, and that acceptance of rent payment does not create a new tenancy with a third party. So basically what this is saying is, if someone is receiving rental assistance, you as the property owner have to accept that third-party payment. You can't deny it. And again, this went into effect in 2019, so even pre-COVID. All right, so now we're going to talk about rent increases. How do you increase rent under the law? So you have to be in compliance with the CSFRA to give a rent increase, okay? If you are not in compliance, then that rent increase is unlawful. You are violating the law, and if you violate the law for one tenant, That makes all of your tenancies in violation if you give rent increases to them. So it can be a really big problem really fast. So you can only give a rent increase when at least 12 months have passed since the last rent increase. The annual rental housing fees are paid. The property is registered with the city at that portal that I talked about at mvrent.mountainview.gov. The owner, you're in compliance with other provisions of the CSFRA, including not having outstanding code violations on the property, and your property is maintained appropriately. And the last one here, the tenant was served a 30-day notice as required by state law in writing. The other piece of this is if you give a banked rent increase, which we're going to go over, and you don't provide the mandatory required language, which we have on a form for you. As a property owner, we make all of these handy forms, including a rent increase form that has the required language. If you don't, then that rent increase is not valid. Okay, so what are the AGAs? You can see here, we are going 5 years back. There are more AGAs than this, but for brevity's sake, I'm only showing the 5 years. This year, this new AGA, the 2024 AGA is 2.4%, and this is applicable between September 1st of 2024 through August 31st of 2025. This is the time period when you can give that allowed rent increase and have it not be petitionable against. So if you save this rent increase, it just, as I was saying earlier, becomes a banked increase, which is what we're going to talk about now. And they just hang out in that bank in perpetuity forever, unless the tenant moves. As long as it's the same tenant, they're just there, hanging out, waiting to be used. So if you give your AGA and then you still have a banked increase, you can add that to your AGA up to 10%. That's the high cap. And give those rent increases, the AGA plus the banked increases together. Now, they come with specific requirements. Like I was saying, there is a specific form that you have to give that has mandatory language about what we call the tenant hardship petition. So banked rent increases, a tenant can file a petition with the city saying, I can't afford to pay these banked rent increases. And then that goes, there are qualifications, which we'll talk about in a little bit. And that goes to a hearing, and a hearing officer determines the outcome of the rent increases. So there's a lot to it, but if you don't give that form with that required language, then, and you give a banked increase, that bank rent increase is technically not valid, which means you're in violation of the law. So for noticing rent increases, you have to give under state law at least a 30-day notice, and you can only give one rent increase every 12 months. And with a banked rent increase, you have to give that mandatory language as I was talking about, and you have to file a copy with us through that registration portal within 7 days of the notice of the banked increase. So this always leads to a question, well, when can I raise my rents to market? And there are two types of ways that can happen. One is a voluntary vacancy. So that's called vacancy decontrol. A new tenancy starts, that people that were in that old lease or in that old rental housing agreement are no longer there. It is an empty unit. Then you can reset the rent to whatever market is. Okay, so that's the most common one. The second one is if there was a lease, and let's say, you know, someone moved in, there's a roommate situation, and one of those roommates moved out, that was on the original lease, and there's a new roommate. That is fine, the rent still holds at the same amount, but then this other person who was one of the two original tenants, they move out too, and someone else moves in. Now there's two new tenants. Then you can raise the rent to market because there's no one that was originally on the lease still in the unit. So it's basically like vacancy of a vacant unit that has people living in it because they're holdovers. And then there's this question of who is allowed to live in a unit. So who can come in to the unit when there's a lease? The first one is eligible family members. They have to give notice to the landlord, and the property owner can request, like, please verify your identity and that you are really a family member of this person. So this can be a parent, a grandparent, aunt, uncle, a child. And then the tenants need to notify us of this additional occupant within 10 days. So just like the landlord has access to our portal, tenants have access to our portal, and they can upload the forms there. Replacement roommates are allowed to live in the unit. If there was a roommate and that roommate moves out and a new roommate moves in, as long as some of the original tenants or one of the original tenants from the lease is there, someone can replace that unit's roommate. There has to be, mandatory notice to the landlord from the tenant. The landlord can perform a tenant screening in this case. Can't perform, I think, a full tenant screening in the eligible family member case. And the tenant has to notify us. And then if the lease allows it, adding roommates, this is different than a replacement roommate. This is actually adding a roommate. Subletting, those are allowed to happen only if the lease allows it. And just as a side note, the subtenant rent cannot exceed the total rent due to the landlord by the original tenant. So the tenants can't make money off of having subletters. And they can request a disclosure of the rent terms. Okay, before we move on, are there any questions about who's allowed to live in the unit, rent increase, basics of rent increases, and anything in that world that anyone has questions about? Again, if you have questions about your base rent or lawful rent, contact me. If you think that maybe you gave rent increases when there was a code violation, or you were out of compliance with the law, or you didn't register, or you didn't pay your fees, all of those rent increases are unlawful. You have to roll back the rent and provide rent credits. If you think that happened, contact me. We don't want you to go and have these large payments that are due. Rather just get it addressed and taken care of and help you through that process upfront so it doesn't get worse. Okay, petitions. So what happens if you are out of compliance with the law? Tenants can file petitions with the city to request a downward adjustment of rent. What happens if you're not able to maintain your operating income, or you have a big capital improvement project on your property? You can file a petition. So property owners can file petitions and tenants can file petitions. So we have a few reasons for why you can request an upward adjustment of rent. We have two types of landlord petitions that allow you to request an upward adjustment of rent to ensure a fair and reasonable rate of return on your investment. The first one is a maintenance of net operating income petition. And then the second one is a specified capital improvement petition. So if you have a big project on your property, like a re-roofing, which are expensive, you can request a rent increase through our petition process to cover the costs of that project. It might not cover the full cost, but it will definitely cover a portion of it. I really encourage these. It's really important to maintain your building, and there is a way to cover the costs that is very helpful to putting a new roof on a building. And then there's also something called a joint petition. These have to be filed by the tenant. They're filed with you, in agreement with you as the property owner. It could be for newer additional housing services. If the tenant really wants a brand new, carpeting or flooring that is above and beyond just normal repair and maintenance. This is one way that you can work with the tenant to achieve that goal. And then also, if there's an additional occupant who's neither an eligible family member or a replacement roommate, there's a way that the tenant could request rent increase within certain bounds to accommodate that. Tenants, as I mentioned before, can file tenant petitions to request a downward adjustment of rent for 4 reasons. One is the unlawful collection of rent. So if you were increasing rent or charging rent that was above the lawful amount for any reason, including giving unlawful rent increases, the tenant can petition the city requesting a downward adjustment of rent for that. If you failed to maintain the habitable premises, so if you didn't maintain the building to code, or if there were egregious error issues on the property, the tenant can file a petition. And they can also file a petition for a decrease in housing services or maintenance. So remember how we were talking about earlier, there's a pool on the property. That's a housing service. It's part of the lease. You want to take that pool away and you don't reduce the rent in some commensurate way, then the tenant can file a petition saying, hey, we used to have a pool. My rent covered the use of that pool. Now I don't have one. I'm still paying for that pool that doesn't exist anymore. What do I do? Well, they file a petition with the city to request a reduction in rent. If there's a maintenance reduction, they can also file a petition. And then the last one is the undue hardship petition, which that is related to those banked rent increases we were talking about. Tenants can also file them if you as the property owner request a maintenance of net operating income petition to adjust the rent up. Okay. So before we move on to habitability, and I do want to note the time, we can go over this a little bit time-wise, but are there any questions about petitions? So it's a whole petition process. We also, in the background, have that big one that I was talking about with Eduardo, the one-time utility adjustment petition process. That's separate from our normal ones. The ones that I just reviewed were like the normal typical ones. We also have this other one that you need to be aware of, because you as the property owner you have to file a petition with us, regardless of whether you utilize REVs on your property. So get in contact with me, say, Patricia, I need help with this, and we will get you help. So I'm going to keep going if there are no questions. Okay, seeing none, we'll keep moving forward. So the next up big question is habitability. There are laws about this, right? There's state law called the implied warranty of habitability, and this defines certain standards of habitability that landlords must meet, including Civil Code section 1941.1 and health and safety codes. You should read these as a property owner. You should know these as a property owner. I mean, not all of the details, but you should have a pretty good grasp of what it means to maintain your property and to maintain those standards of habitability. You are responsible for this property. There's also local code, and it provides clarity and details about habitability standards that are specific to Mountain View. And this includes City Code Chapter 25 and CSFRA Section 1706S. So what is a tenant responsible for? Because they have responsibilities in maintaining the property too. They have to take reasonable care of the rental unit and the common areas. They have to notify you, the landlord, when problems arise, and they are responsible for damage caused by the tenant, their guests, children, or pets. And that's under California Civil Code 1941.2. So again, go and read those civil codes. It's really going to be helpful to you. And then landlords are responsible for providing rental units in habitable condition. And this is the Civil Code 1941.1. And this includes things like you have to have properly functioning plumbing and gas pipes and sewer systems. There needs to be no holes in the roof or the exterior walls. Everything has to be, blocked off and closed up for vermin, and infestations of bugs have to be dealt with. There have to be properly locking doors and window screens, and you have to provide heating and electricity and water. So you're going to want to know these laws. That's really important. And again, it's a safety issue too. So what do we recommend for habitability to kind of get that balance between the landlord and the tenant, so there's no they said as they move forward, and go into their tenancy and then leave a tenancy? You're going to want to have a very thorough walkthrough inspection. So you have a tenant who leaves, you get the apartment really clean or the house really clean and painted and ready to re-rent. Everything looks great. Well, you're going to want to document that. Okay, so go ahead and get a checklist There are checklists on the California Apartment Association's website. Just get that checklist and then go through really thoroughly on your own, make photos and videos, and then go through really thoroughly with the tenant and make photos and videos and say, hey, this is what this unit looks like, and you have the documentation and they have the documentation. Require that renter's insurance in your lease. So you can require that, make it mandatory, and it is really affordable. On a personal note, I didn't have it when I was younger, and I found out that it was, less expensive for me to insure my rental unit than it was for me to not insure it, because it lowered my car payments. So if someone is, saying, oh, I don't know, if one of your tenants is saying, oh, I don't know if I'll be able to afford that, you can provide them with that little anecdote and maybe it'll help them check it out. But you can just make that a requirement in your lease. And then one of the great things that we have here in Mountain View is a mediation program called the Mountain View Mediation Program. And it can help if there's disputes about security deposits. And it can do that really quickly. So it's very, it's free, it's very effective, and it's less adversarial than having to go to court. So it's a really great tool. If you have questions about it, it's something that our office actually helps. It's a program that our office oversees. So you can just reach out to me and we can get you in contact with them if you have any need for dispute resolution services. Again, it's free and it's a really great program. And so before I move on, does anyone have any questions? Oops. Okay, seeing none, we're going to talk about the right to enter. So lawful entry, this is all within the California Civil Code. So lawful entry is only for necessary or agreed upon repairs or services or allowed inspections. Just going into a unit for no reason is not allowed. You have to give 24-hour written notice unless it's an emergency, okay? If there's a fire or flooding or something crazy happening in the unit, the 24-hour written notice does not apply, but in general, it usually does. You need to state the time and date and purpose of entry, and the entry has to be done during normal business hours. The tenant does not have to be present. They have the right to be present, but they cannot lawfully deny entry. That would be a failure to give access cause for termination, which can be given if they continually deny access to the unit after a notice to cease is given. Okay, so really quickly, we're going to go over the termination of tenancy. This includes what are just cause noticing, just cause eviction protections, the noticing that's required, tenant buyouts, and potential reasonable accommodations. So I'm going to keep going through this. If you have to hop off, please go ahead and do so. I will send a recording of this workshop out tomorrow. If you can't stay, you'll still have the recording. Okay, so just cause evictions. This is the second half of our law. So we've talked about rent stabilization protections for the first half, and now we're going to look at the other part of it, our just cause eviction protections. So there are only 9 reasons in the city of Mountain View why a tenancy can be terminated. This includes the failure to pay rent, tenant causes, failure to pay rent, breach of lease, nuisance violation, criminal activity, or failure to give access to the unit, which is what we were just talking about. Those 4 that have the asterisks, you have to give a notice to cease to the tenant before using that type of termination notice. And then there's the landlord caused terminations. This includes repairs or temporary vacancies to the unit that last 30 days or less, owner move-in, the withdrawal from the rental market, and demolition of a unit on the property. Those ones that are property owner caused require payment of relocation assistance to qualifying households and the first right of return to that unit. So I do want to mention before we move on that not having a lease in Mountain View is not a reason for termination. Okay, so just because someone does not sign a new lease at the end of their lease term does not mean that you can terminate them. If they don't want to sign a new lease, they don't have to. The lease terms from the previous lease just stay in effect, and the tenant has the ability to file a 30-day notice to vacate, but you do not have the ability to give them a 30-day termination notice or any kind of termination notice related to like a month-to-month tenancy. So essentially what happens is if there is no agreement on a new lease, the tenancy becomes month-to-month for the tenant, but not for the property owner. Okay, so this is what the eviction process looks like. You give a notice, a termination notice to the tenant and file one in our system at the portal with us. You're going to file that with us. I think it's within 3 days of serving it on the tenant. And if they don't, correct the violation, if it's a tenant cause, this is only for tenant caused terminations. There's a whole bunch of different timeframes for those ones that are landlord caused. If it's a tenant caused violation, termination notice, and they don't address the issue through the notice to cease, and then you go and you actually serve a full termination notice on them, or it's a 3-day notice to pay rent or quit and they don't pay the rent, then you can move on to the unlawful detainer servicing. They have 5 days to answer. This is business days. This does not include weekends or holidays. If they don't answer the UD servicing, it goes automatically to the judgment by the courts, and then the sheriff's notice they come, they knock on the door, and they remove the tenant. If the tenants do answer the unlawful detainer, then it goes to court, and there's a longer process there. And I want to remind everyone that constructive evictions are not allowed. What does a constructive eviction look like? This is like changing the locks, cutting off utilities, not maintaining the unit so that it forces the tenant out, harassing the occupants, preventing people from entering their unit, and like I was saying, unaddressed habitability issues. These are all illegal under state law, and tenants can file for damages against you if you do this. Okay. Noticing of termination notices. There are specific and different types of noticing. So if you are giving a termination notice for those landlord caused reasons, the notices are 30, 60, and 120 days or 1 year. And then you also see here we have the 3-day noticing. That's for 3-day notice to pay rent or quit. If there were those ones that were those termination notices that were as a result of a tenant's action, you have to give a notice to cease, and it has to include our phone number at 650-903-6136. If the termination is due to the withdrawal of a rental unit from market with for redevelopment or for other causes, then there's a whole special process. That's where that 120 days or 1 year come into effect. And that is something that you will be working closely with the city on. That's when our tenant relocation assistance ordinance comes into effect. And there's a whole process. You don't go through it alone. We walk you through it every step of the way and provide support to both you and the tenant for that type of termination notice. But it is a process, and you have to work with us through it. So another way to look at this is like this. Noticing for 3-day notices to pay rent or quit. Obviously, that's obvious. It's a 3-day notice. It says it in the name. If for owner move-in, and for temporary withdrawal from the market due to construction activities, and for demolition, I think it's a 30-day notice if the tenant has rented for less than a year, and a 60-day notice if the tenant's rented for more than a year. And in the case of the withdrawal of the unit from the rental market completely, like I was saying, it's 120 days for most people. And then if the unit has a tenant who is a senior or disabled, then it's a year, and that's a state law requirements. I mentioned this before. If you give a termination notice on during the week at some point, like on a Friday. Weekends and holidays are not any longer included in the calculating of response times. So for instance, if a 3-day notice is given to tenants on a Friday, then the tenant has to pay the rent by Wednesday. If a 5-day response UD notice is served on a Friday, then the response is due on the next Friday. Okay. Before I move on, that's all that we're going to be talking about high-level eviction information. Does anyone have any questions before we go on to tenant buyouts? All right, I don't see any hands raised, so we're just going to keep going. Tenant buyouts. So tenant buyouts are an agreement through which a landlord pays a tenant money or other consideration, including but not limited to the waiver of rent, in exchange for the tenant leaving and vacating the rental unit. So you can do this. There is a form, a disclosure form that has to be signed by the tenant before beginning negotiations. And then there's the agreement. The tenant has the right to refuse the agreement. The agreement must include considerations, the date to vacate, and disclosures of the law. Then there's required noticing. You have to file a copy of the disclosure form with us before the process starts and the content of the agreement online. And then the tenants have the right to rescind the agreement within 10 days of signing it. Okay, so they can sign the agreement, and then within that time period, they could come back to you and say, nope, I'm not willing to leave. I take this back. That is allowed under the law. They have 10 days to do that. All righty, we made it through that section. Okay, so now we are at post-tenancy. What happens at the end of everything? We have our security deposits. So the tenant is moving out. What do we do? So you are allowed to deduct past due rent that was not paid, damages to property that are beyond normal use, normal wear and tear is allowed. If a person's lived in a unit for 5 years, there's going to be normal wear and tear, just like there is at your house. And you are allowed to deduct for cleaning if the tenant leaves the unit, you know, in an unclean state. So for the timeline of when people move out, there's typically an initial inspection that's done at least 14 days before the tenant moves out. The tenant then moves out and a final inspection occurs. And then you as the property owner send the rest of that return deposit to the tenant with an itemized list of deductions within 21 days after move out. It has to be done under California state law within 21 days. For this process, just like you did at the first one when the tenant moved in, we recommend you take photos, take videos, have that checklist. In fact, the checklist has, you know, when people move in and then when people move out. So usually it's like both. You can see it right there. I know I have a copy of one. It makes it really easy to review, but make sure you have those photos of what it looked like when people moved in and what it looked like when people moved out. And so you can just document the whole process. And so it's just a really good best practice to do. Okay, tenant relocation assistance. What happens if someone moves out, or what happens if someone qualifies for tenant relocation assistance for those landlord caused terminations? So withdrawal of the unit from the market, owner move-in, demolition, those ones. Tenants have a right, if they qualify, to relocation assistance and a first right of return. So relocation assistance includes the refund, a full refund of the security deposit, 60-day subscription to a relocation agency, 3 months rent for an average similar size unit, and an additional specified amount plus the consumer price index percentage for special circumstances if there were seniors, minors, or disabled people living in the unit. This is required if people income qualify. If your tenants income qualify, this is a requirement under the law. Additionally, tenants have a right to first return if the unit returns to the market. There's also some other situations, like if it's a property that is coming back onto the market after being built, if it's new, There are still first right of return rules for tenants who move out due to terminations related to those owner caused reasons. So if the unit returns to market within 2 years, the tenant can file for actual and exemplary damages in court. There is also vacancy control for the first 5 years of this 10-year term period, where the tenants have the right to move back into the unit at the amount of rent that they were paying, plus any applicable annual general adjustments of rent. And then the last piece is they have the right to return to the unit regardless of that vacancy control issue up through 10 years. So you can negotiate the rent amount for years 6 to 10. And for years 1 to 5, there's that period of vacancy control where it has to be the same amount of rent plus any applicable AGAs. And then finally, this is just another overview of the first right of return so that you can understand the process a little bit more. So following why would this happen if the same rental units return to the market or there's other laws that fall into place that cause this trigger? The tenants have to let the owner know in writing if they're interested in first right of return before they move out, and they have to provide a forwarding address. And the owner is obligated to inform the city and the tenant when the unit's being re-rented. So the owner has to let us know and the tenant who expressed interest in returning to the unit if it did return to market. Okay, so we are at the end. I'm just going to share some resources with you really quickly that are available for the Mountain View community. The first is that mediation program that I shared about earlier. It is free. It offers an opportunity for parties to receive dispute resolution services with a trained mediator to help come out with an agreeable, I was going to say positive, but it might not be for either party, an agreeable outcome between parties. And it is confidential. It also has a really high success rate. It's like 95% when both parties choose to mediate. So it keeps people out of court and it maintains relationships. It's a pretty great program. And again, it's free. You just contact us, mvrent@mountainview.gov, and we can get you in contact with the mediation program. Okay, there's also some legal resources that you should be aware of. The Santa Clara County Bar Association has a great website with a ton of information. And then there's the Superior Court Self-Help Center, very useful tools. Also, the California Apartment Association is a great resource for property owners. They're going to have a just wealth of information to support you. There's also put out by the state, the California Tenant Landlord Handbook. It is a fantastic resource, and I highly recommend that you print it and you read it. You have a copy for yourself, you have a copy for your tenants. It is just a phenomenal resource put out by the state. It doesn't obviously cover our local law, but it covers state law in just a way that's easy to understand and very informative. There's also, like I mentioned earlier, our required information sheet that you have to give out at the start of a new tenancy and every time you increase rent. I'm going to send that tomorrow with the PDF copy and the link to this workshop, so that you have that information, but I'll also include the FAQs. So you'll have, if you went and downloaded the California Landlord Tenant Handbook, you'll have all of the state information, and then I'll send you the FAQs and the required information sheet. All of those things that the city puts out are also available on our website at mountainview.gov/rent stabilization. If you go there, you're going to find a bunch of information. You're going to find, what is the AGA? When is the rental housing fee due? You're going to find information out about our workshops, all of our forms, everything. It's a robust website, and it is there for you to support you as a property owner. And then some more information on where to get help. Every Thursday, we have a housing help center for landlords and property owners. It is both virtual and in person. So if you came to our office at 298 Escuela between 1 and 3 p.m. on a Thursday, you can receive one-on-one support from one of our wonderful staff members. Or you can join virtually at mountainview.gov/housing help centers, housing help clinics, excuse me. We have a lot of websites. I'll put that in the chat for you. So it's mountainview.gov/housing help clinics. And that is how you access those help centers. And then we also have office hours every Tuesday that are virtual only from 10 to 12. We have housing help centers for tenants as well. So if your tenant needs some assistance, they can come to our housing help center from 6 to 8 p.m. There's one tonight. And we actually connect tenants with a bunch of different housing support services. So if you have a tenant who's struggling to pay rent or needs assistance in some way, they can come to us and we can help them. It's a great tool. And I know a lot of landlords have referred their tenants in the past to our housing help center. Again, it's also available virtually, same link as what I shared in the chat. And then you can contact us. We are here to help. We are very responsive, or at least we try to be. You can call us and leave a message at 650-903-6136. You can email us at mvrent@mountainview.gov. You can come to our office. Really prefer that you contact us first and make sure that we're available to assist you, or come to our housing help centers or office hours. But we can schedule appointments with you as well. And then again, you can learn a bunch of information out about the division by going to mountainview.gov/rent stabilization. And just as a final reminder, I know I just mentioned it, but just to keep it fresh in everyone's mind, we also have office hours virtually every single Tuesday through Zoom from 10 a.m. to 12 p.m. And you can access those by registering at mountainview.gov/RSP office hours. And that is the conclusion of our workshop overview. Does anyone have any final questions before we wrap up for the afternoon? If you do, just go ahead and raise your hand and I'll allow you to talk. If not, that wraps up our workshop today. It doesn't look like we have any questions. So reach out to me. You can, again, reach us at this information, contact information here, or you can email me directly at patricia.black@mountainview.gov. So thank you so much for joining us. Thank you for having great questions. And again, anytime you need support, we're here to help. We provide just as much support to property owners as we do to tenants. And we are ready to answer your questions. So yeah, reach out. And otherwise, have a wonderful afternoon. Enjoy your Thursday, and we will check in soon.